Hi, good morning to one and all. I welcome you all to the next lesson where we will be starting and completing this entire chapter. Before I start, I need a thumbs up from you all in the chat box that I'm audible and visible.
Good morning to one and all.
And I will completely finish off this chapter. Okay. So let's see. Okay. Yeah. So just in the chat box, if I'm audible and visible, and that's it, we are good to go. Right? Can we start with the lesson? Just waiting for your confirmation so I can quickly start and complete this entire chapter, that is evaluation of labor legislation and need for the labor code. Today we'll be talking about the labor codes, highlights of the labor codes which have newly been introduced, and it is applicable, the highlights are applicable for your exams as well. Okay, so just if I'm audible and visible, please put it on chat box. Great. Thank you so much, Shweta, Lakshmi. Great. Let's start. Hi. So we'll be starting with one important topic of labor laws. We will be evaluating the labor legislations and the labor codes which have been introduced recently. Now, before we start, let's understand that how did the labor codes come in force in India. So very important is the second National Commission on Labor. They recommended that there are multiple labor laws in India, over 50 laws, 50 acts were there of labor laws. They said please cut it down into 4 to 5 acts only 4 to 5 labor codes. Please consolidate, combine all these multiple laws into 4 to 5 labor laws, said by the second National Commission on Labor Laws. Pursuant to that recommendation, we went ahead and brought in 4 labor codes in India. That is the Code of Wages, the Social Security Code, the Safety, Health, Working Conditions Code 2020, and the Industrial Relations Code. So in India, we have only 4 labor codes at the moment. So we followed the recommendation and brought it down into 4 laws only. Now these labor codes, we will see when they have been notified. The Code on Wages Act 2019 has been notified on 8th August. The Industrial Relation Code was notified on the 28th September 2020. Your Social Security Code was notified on 28th September 2020. And your Occupational Safety, Health and Working Condition Code was notified on 28th September 2020. Now, what are these codes? What have major changes they have brought? What is the revolutionary changes? We will see in the later part of the lesson. First, we will talk about the history of labor laws. Okay, we will talk about the history of labor laws. Now, labor laws actually had started gathering importance and gathering formalization, proper laws, from the origin of the ILO. So when the International Labour Organization was established in 1919 as an agency of the League of Nations following the Treaty of Versailles after the First World War. So what are we seeing? So we are seeing that how labor code is there today, but before the labor law we are seeing the full journey. So the journey, one significant, came after the World War I. Moment the World War I ended, they started saying that listen, countries are not talking with each other. Internally, everybody has become very, very economically backward. Imagine after a world war, what will be the situations of the countries? what will be the situation of the workers there, employees there, workmen there. So then we made, as a agency of the League of Nations, like how we have United Nations now, that time it was League of Nations, a ILO was established in 1919. Okay, it was after the Treaty of Versailles. Okay, so this was the first organization to deal with the labor issues. So that's how it started. And post the World War One, they started thinking about reconstructing the country, reconstructing the laborers, reconstructing the entire society. In Great Britain, in UK, the Whitney 4 Commission, a subcommittee of the Reconstruction Commission, recommended that in its 1918 final report that industrial councils be established throughout the world. Now, Great Britain, they said that industrial council should be established throughout the world. Now, so pursuant to that, we also became a member of the ILO, International Labour Organization. So we were permanent members from the beginning of ILO. India is a founder member of the ILO. That is, moment ILO was formed, we were a member of it. Okay. Now it came into existence in 1919 and have been a permanent member of the ILO governing body since 1922. So we are also a member of the governing body. So understand, there are over 187 members. ILO has 187 members, that is member countries. So 187 countries have signed, are signatories to the ILO. In that ILO, there will be a governing body that is the principal decision making body, like the board of directors. India is a member of that, okay, from the 1922. The ILO structure is tripartite. The International Labour Organization is tripartite structure. So what do you mean by tripartite? Tripartite means three parties. There are three parties to this particular ILO membership. Okay. So who will be the first one? So very simple. At the unique feature of ILO that it is a tripartite structure between the governments, the workers, and the employers. So let's see. Understand what it is. First, there will be the governments of the world. Then these governments of the world will have signatories that listen. All the employers of the world will also be a part of it. That is, they will represent, some of the employers will be represented there. So there will be employers representation and also workmen representation. So that's how the country can function or ILO can function. Now logically, understand, it can never be that it will be only labor centric, labor favoring, because then businesses will say that, listen, how do you run a business? How do we make profit? If no business, no employment, okay? So we have to keep it balanced. So to ensure that there is a proper balance structure, a tripartite of all the three affected persons are there. The government, the employers representation, and the workmen representation. Now, why should we bring the labor code? So we understood the ILO is a part, India is a party. Now what about the labor codes? Why did we bring the labor codes in India? So as I told you that there were over 50 laws, 50 labor laws. Okay. And if you go to see, break it down into furthermore, there were over 100 laws, 100 labor laws to be followed by a business. Because of these multiple laws, there were multiple registrations, multiple compliances, multiple maintenance of registers, multiple return filing, different conflicts. Wages under one act was defined differently. Workmen under different act was defined differently. Industry was defined differently. So it led to lot of conflicts and confusion. So, and also if you go to see, the other simple reason is the labor laws, if you will see, are of even before the independence, those labor laws are being functioned even today. So the old labor laws really never had a revolution or any kind of massive change for a long period of time. The need to bring, because everything became outdated, everything had to be as per, there was nothing mentioned about technology. The new labor laws also talk about the using technology, connecting your Aadhaar card with the PAN card, all those facilities are there. So let's see, multiplicity of labor laws. Now, labor laws are under the concurrent list. That means the state makes multiple laws, that is the center or the federal government will make the multiple laws, and the state will also make multiple laws. So therefore, it was made by the union government also and by the state government also. The resolution of the labor disputes, whenever there were labor disputes, there had been a lot of federal laws, 100 federal laws, and also these labor laws were remained untouched for a long period of time. So then came the entry that, listen, there are multiple laws, it has never been changed, and now the another need is because the second National Commission on Labor, this is very important body, because on their recommendation only the labor codes have been brought into 4, they said 4 to 5, but now we have grouped it into 4 only. After brainstorming, so when they recommended, then there was for many years no action was taken. Then from 2014 onwards, the efforts started coming to make these labor codes, implement these labor codes under the motto of Sabka Saath, Sabka Vikas or Sabka Vishwas. Okay, which means that let's take everyone together, let's take everyone on the same page, let's get everyone's trust and progress. Now, this came, now once the labor codes recommendations were there, obviously there was lot of to and fro, because it has to get approved from both the Lok Sabha, Rajya Sabha, President's assent. So these 4 bills were examined by a parliamentary standing committee. Now pay attention, I'll be telling something very important, that these parliament standing committee gave their recommendations to the government, and then they said that 29 labor laws, okay, will be subsumed in the 4 labor laws bill, and this is which were under the Ministry of Labor and Employment. Now what is this? I will tell you. First, that there were 20 major labor laws, though I am telling you there were 100 labor laws, 50 were there, but actually the 29 labor laws, these were the major labor laws in India, they have been subsumed, means they all will get repealed, okay, all will be removed, and we will have 4 labor codes. Concept clear? So if you will see and count the number of labor acts which have been repealed, it will come 29. They all will get subsumed, will get submerged, will get consolidated into 4 acts only. And these 4 acts are, as we saw, one with respect to wages. So there was one act which was Payment of Wages Act, the other one was Minimum Wages Act. So all those, they said let's club it into one. Then said Industrial Relations Code. So what we had about industrial relation was Industrial Dispute Act. So there were multiple acts which were there, Public Utility Service Act. So they merged it into one. We will see which all it is there, the Social Security and the Occupational Safety Work Conditions Code. So they can ask, okay, how many labor codes have been consolidated? So 29 labor laws have been consolidated. Clear? Now, let's go forward. The purpose of the labor legislation. So we haven't started with the code yet. I think once we complete just the purpose of these labor legislation, then we will get into the labor codes and understand that what are these labor codes and what is the importance of these labor codes. So purpose of labor legislation. Now you tell me, okay, if they ask, or I'm asking you, what is the purpose? Why do you want labor laws in India? So first I will say that, listen, we want progress. If the relations are maintained, employer-employee relations are there, the country will progress, the workman will progress, the employer will progress, the society will progress, the country will progress. So it will lead to productive economy. One. Second, there will be less disputes, right? Less disputes, or we can say that everything will be clear, so disputes will be resolved faster. So therefore there will be harmony, there will be trade unions to explain, to reduce the pressure, or we can say interpret the issues, settle the issues, give settlement options. So because of these things, labor laws, there will be harmonization in industrial relation. That means the workmen and employer related issues will reduce. And third, the purpose could be reinforcement of fundamental work rights. That is, we will reinforce, we will assure, we will ensure that the work related rights are maintained, which is our fundamental rights. In the constitution directive principles, it is also said that work right should be preserved. That means if in a country like India someone wants to work, so all the things should be in place. So the labor legislations, all the labor laws provide a clear and constant reminder and guarantee that, listen, the fundamental principles and the right to work has been maintained. So three important points for purpose of the labor legislation. Then we see the classification of the labor laws in India. This is very, very important. Okay, very, very important. And you can start your counting. You will see that 29 acts are there which have been clubbed into 4 codes, 4 labor codes. The first one, industrial relations. Okay, with respect to industrial relation code, there were 3 acts which have been subsumed into the Industrial Relations Act. So first is with respect to industrial relation, that is employer-employee, workmen and the employer. Workmen were very weak, less bargaining power, could not demand, did not know their rights. So they were represented by trade unions so that their demands can be allowed. So the Trade Union Act was there. Then there was something called as Standing Order Act. I will tell you what are standing orders. Standing orders are internal, like how we have a company has the articles of association. Similarly, the factories, your industries will have a standing order. A standing order are the terms, conditions, the benefits given to everyone. So that is a written down terms and conditions which are there. So that is also with respect to relations between them. And third is the major act is Industrial Dispute Act. All these have been subsumed to become one law, which is your Industrial Relations Law. Okay, your act which has become is your Industrial Relation Code. The next laws we will see is Wages Act. Okay, the Wages Code, payment of wages. In the wages also, there were your 1, 2, 3, 4. We had these 4 acts, which was the Payment of Wages Act, when you have to pay, what if you don't pay, what deductions are allowed while paying. So that was given in the Payment of Wages Act. Then the Minimum Wages Act was there separately in India, saying that what was the minimum amount I have to pay. Then in case of bonus provisions were given. Okay, and working journalist Act was there. So all these were different acts talking about the wages. So all of this have been again subsumed to become the labor codes. So these 4 acts were subsumed. Then we had the biggest number of acts which were there, which is your working hours, conditions of service, employment, such as the most important act was Factories Act, okay, which actually spoke about working conditions. All these acts got subsumed, and then came another laws with respect to women empowerment, maternity benefit, equal remuneration. Then your social security legislations were there. So we will see which all it was there. So if you go to see, there were around 51 major laws which were there, okay, and now from there they took 29 laws and converted it into 4. With those 29 laws will come in some time. So first is objectives of the labor codes. Again, as we said, that what is the objective of the labor code? Now what do you mean by the objective of new labor codes? Think and tell me. What could be an objective? Objective is something that I want to do. It is the reason, object of making the laws. There has to be an object, right? Why are you doing this labor code thing? So very important is called as we wanted clarity. Whichever, there were so many times, I will take you all through some incidences which were not mentioned only. Example of electronic, the thing was there, never mentioned. So we required clarity on that. Standardization. The object was to standardize the various different definitions, different terms, everything. So there has to be a standard definition for all, and consistent approach or standard approach. So consolidating the labor laws will help enable a more comprehensive labor coverage. So we will be having a more summarized, more specific, more targeted and a better labor laws in India, because the separate labor laws were there which apply to different employments, different thresholds. So after much discussion, 29 laws have been replaced by 4 labor codes. So it will come, I'll tell you which all it is there. So what is the objectives of the labor code? First, if we see, the object was to bring in clarity and standardization, to involve technology also, which was not there earlier, to make a comprehensive labor coverage, to be more comprehensive labor coverage by consolidating the various laws. So comprehensive means one in all. To provide for minimum wages, to provide for industrial harmony, to enhance the social security, to provide health, safety, to ensure that the proper enforcement of these things were there, strengthening the enforcement laws. That means whatever benefits are there should be enforced. It shouldn't be on paper, living documents. And gender equality, that equal remuneration for men and women. So these were some of the objects of passing the labor laws. Standardization, clarity, comprehensive, minimum wages, your enhancing the security, etc. Now features of the labor law. Now what are the features of the labor law? Very simple, size based. So here normally in this they said that labor codes will apply if you have a certain number of employees, right? So it is size based application. Doesn't mean everybody has to follow the labor laws. If I have 3 employees, I don't have to follow labor laws. So they will tell that as your size increases, okay, as the your workforce increases, your industrial presence increases, the number of labor laws will also apply and the compliances will also increase. For example, they say that if you have more than 500, then you have to appoint a safety officer. Then that's another threshold, welfare officer. So as the size of the organization increases, the number of laws and number of provisions and number of compliances will also increase. So less small the size, less the compliances. So normally they say that for 10 or more it will be applicable. Then from here you can read it up. the important ones I will take you through. Then comes operational flexibility. Okay, now what is operational flexibility? Previously, establishments with 100 or more employees needed a government approval for operational changes. Now, will they increase the limit or decrease the limit? What are they saying? That whenever there were 100 or more, they required government approval. So now they say that, listen, if we make this limit to 300, lot of businesses will be happy, because those who have 100, 150, 200 will not have to take approval for making operational changes. It is only for bigger entities. When now, earlier it was 100, now they've increased the limit to 300, that if you have more than 300 employees, then if you want to make operational changes, please take a government approval. So they will address the compliance complexities which are there. So these are some of the features. They have streamlined and simplified everything. They made single registration. This is also a very interesting point, that for provident fund separate registration, for insurance ESI separate registration, for workmen separate registration. They what nonsense, different laws every time, different registration. They said no, now we are making a single registration, okay, to get single license for all the codes. So it's a beautiful, excellent provision. So all the compliance complexities have been addressed. Contract labor has been defined and we have given them lot of support. They have introduced the concept of fixed term employment. I will tell you in some time what it means. What does contract labor also means? Contract laborers are those workmen who are employed by a contractor. So when a contractor employs someone, they are called as contract laborers. Okay, with numerous trade unions, the industrial relation codes provide for formal recognition. So the trade union have been recognized, okay, under the code. Obviously earlier also it was there. Gender equality, okay, gender equality is something which was there in the constitution also, and earlier act was also there, and now also they said that, listen, there should not be any discrimination on the basis of gender. Okay, equal work, equal pay for equal work. Simple. Then comes advisory boards. Both advisory boards mean what? See, imagine now we made the laws, but a span of 10 years, 5 years down the line, 7 years down the line, the government will require some kind of inputs, advices on what is going on, what all changes need to be done. So what they have said, that both the central and the state advisory boards will be established. So these boards will advise the government, okay, on what all changes have to be done. And most important, 1/3 of these boards will be women. So we are giving, we are uplifting the women, giving them, we can say that we are protecting the women and giving them employment. 1/3 of the board will be women. The board will give their respective governments advice. These advisory boards will give advice on matters such as minimum wage, expanding the women in workforce, because if you see in today's time, the number of men working are a lot more, but women in key positions are very less. We want to increase that, or at least bring it to equal numbers. Penalty for violation. Okay, so the code outlines a penalty if you're underpaying the wages or violating any code. The maximum punishment is 3 months in prison and fine up to 1 lakh rupees. So if you see, this is the first time you go to see they are talking about imprisonment. They are talking of heavy fines as compared to what was there last time. Now this is what is important. Okay, this earlier this table is most important. So your Code of Wages Act, so these are your 4 labor codes which are there. Code of Wages has subsumed these 4 laws. Then Occupational Safety and Health, so it has subsumed these 13 laws. Your Industrial Relation Code, okay, has subsumed your these laws. and your social security code has subsumed your 9 laws. Clear? So we will go and get into each of them and understand what it is there. So let's look about the new labor codes in India. What is new and what is the salient features or the highlights of this. So code on social security. The word social security, you will see this in many developed countries such as Canada, where if a person is unemployed, they get unemployment allowance from the country. So in Canada, a Canadian, if he loses his job, he gets paid from the government. So this is the kind of social security. A social security is extended to a person in time of difficulty, in time of retirement, in time of disablement, in times of retirement. Okay, in all these cases, or unemployment. To ensure social security to all the workers, the central government has amalgamated these laws into the social security code. So let's look at the features of the social security code. First of all, it has consolidated multiple laws. So let's see how many laws they have done for social security. So in social security, 9 labor laws have been subsumed. That is, you see, Insurance Compensation Act, your Maternity Benefit, Payment of Gratuity Act, okay, Provident Fund. So all these were your important acts which have been subsumed into the social security code. So it has consolidated all these 9 laws. It aims to provide security benefits to its employees, including unorganized sector. Now this is the first time where unorganized sector is also covered. Now what is unorganized? See, organized sectors are those where you have a formal employer-employee relationship. So they were always covered under the labor laws. But nowadays people have these part-time workers, they have these freelancers, they were never covered. Now unorganized sectors such as self-employed, or we can say freelancers, are also covered here under the social security this. Then they have introduced a provision of creation of national database for unorganized sector, because the unorganized sector were never getting any benefits. Even a house help at home who comes to cook at your house, they will also get protected under these social security regulations. Okay, where you don't have formal structure of employer-employee, any agreements, they are also covered. Then your establishment of a social security fund. So they are saying that, listen, from where will you pay all these people? So social security fund will be created. And even gig workers are covered. Gig workers are unorganized sectors. So let's understand what is the concept of gig workers. Very, very important, newly introduced under the Act. So section 2, subsection 35 defines what is a gig worker. A gig worker is someone who is outside the traditional employer-employee relationship. That means they are not having employer-employee relationship. They are outside of that. Sir, can you give an example? But they help perform certain work. They are helping perform certain or completing certain tasks, but are outside the traditional employer-employee work relationship. Can you give me an example of gig workers? Okay, so let me tell you. When you see these fast food delivery people, when they come, Zomato, Swiggy, Zepto, Amazon, now they are not necessarily employed an employment letter. They are hired, they get per delivery, they get money, and that is done. Uber bike. So these are all these gig workers. It can come because they might not get a formal employment letter. For per delivery they must be paid something. So these were never covered under any labor laws, and now this is the first time where gig workers are also covered. So gig is simply which are not employer-employee relationships traditionally, but they help to complete certain tasks. So let's see the salient features of the Social Security Code. So remember, Social Security Code is talking about insurance, is talking about compensation. So I'll mark the important part. First is it is a comprehensive code, a complete code which is targeting organized as well as unorganized sectors, which was never there before, and self-employed such as gig workers also, freelancers also. Government has said to create a social security fund. Okay. Social security for the unorganized sector, so that in case if they also have issues, we will have to first maintain a database only of how many people are working in unorganized sector. So even a database is to be created. We'll see where it is given. Creation of a database. See, a national worker database. A central repository will be curated. A central database will be created for workers from unorganized sector. Okay, then comes the ESI benefits will be given. The ESI, the Employee State Insurance Act, okay, and benefits will even be given to unorganized segments. Then clear definitions have been given, as we saw, of gig workers, even platform workers, those who are working on the platform for sweeping. You don't have formal agreements with them, so even they are covered. Employment benefits for hazardous job. So even if you're taking some hazardous job, you will get this particular benefits. Women can also now enter into hazardous jobs if they are agreeing to it. Okay. Inclusion of plantation workers. So almost they have expanded the definition of workmen to cover all these non-traditional and new age type of businesses, and they are workmen as well. Then mandatory ESI for hazardous institutions, entities operating in dangerous. These are mandatorily have to get registered for the state insurance, because we know that those who are dealing in hazardous industries, they can cause injuries to a lot of people. So it's better to get all these registered, and we can tell them to get insurances for public insurances also, employee insurances also. Then maternity benefits, what was there, we are giving more maternity benefits have been continued and given more into the current code as well. Appeal mechanism, so if a person is unhappy, he can go to the appellate authority, but he has to deposit 25% of the amount before going in appeal. So if the lower if an employer is unhappy, he said, why the lower court has asked me to pay 2 lakh rupees as compensation, I don't want to give 2 lakh rupees. So he will go in appeal, but he has to deposit 25% in order to be allowed to go in appeal. Then whatever the higher court orders, that can be followed. Equal benefits, okay, for gratuity for fixed term employees also has been allowed. Now let's understand what are these fixed term employees. They earlier never came. This is a new definition that has been added. Fixed term employees. Now we had traditional employees who were called as permanent employees. So let's understand. You had employees, they were permanent employees like we normally understand. Then came fixed term. Fixed term means what, you hire them for maybe 1 month and it is done, and then you leave them. Maybe for seasonal people, you bring them for a certain period. Now even the seasonal people should get gratuity benefits, and the minimum time to work with the company is not required. See, in order to get gratuity, it was said that you require 5 years of continued service. So a fixed term employee who was brought in for seasonal period and then they were removed, so they never had a continuous period, so they would never get gratuity. But now they are saying, listen, this gratuity should be extended even for these seasonal and fixed time employees also. For fixed time they are employed, then they are removed, then again next year they are brought in. So even for them, and they should be treated in par with permanent employees, which is a fair and a good provision and a very labor friendly law. Then online vacancy reporting. Now very simple, if in your workplace, if there are a workforce exceeding 20 members, they are required to post job vacancies online. Now you see, never was in the earlier labor laws mentioned about online. Now they are saying that if you have 20 or more people employed and you have a job vacancy, then please post it online so that more people can get employed. Then universal account number. This is also very, very important and very, very big relief to everyone. Earlier, everyone required a separate registration for ESI, for Provident Fund, for so different you require different numbers. Now they said that a universal account number will be there, in which your insurance, PF will be given, but you need to have your Aadhaar card. It will be allowed, it will be linked with your Aadhaar card. Anyone wanting to get any benefits under the labor codes have to provide their Aadhaar card. Without Aadhaar card, no benefits. Okay, so they will make the contributions, etc. also will be provided on how much the employer has to give, employee has to give. Now we'll see your next labor code, which is your Occupational Safety, Health and Working Condition Code 2020. So this is the next labor code. From here, from the name itself, what do you think this labor code will intend to do? First, we know that it must have replaced a lot of laws. So we will write it as a law which has consolidated all the other existing laws which relate to safety, health and working conditions. Okay, and this will be a social welfare legislation, a law which will be in favor of the workmen. Now let's see some of the highlights of this particular thing. I look at some of the highlights which was not there in the earlier thing, or the highlight features. First, unification of registration. All establishments having 10 or more workers are required to obtain registration within 60 days from the code, and all the requirements of health and safety are to be given to all the factories having 20 or more workmen. So very simple. If all establishments having 10 or more are required to obtain registration within 60 days of the code. So moment the code was passed, within 60 days all will get registered there. And all the requirements of health, safety to all the factories having 20 or more people. So you have to get registered when you have 10 or more within 60 days of the code, and the benefits have to be given whenever you have 20 or more persons in the factories. Next, one very important which was never there before, where they were saying that, listen, so many times in all these factories, the workmen, you employ them, you never had any agreement, so they don't have anything to prove that they were working with you. They have no benefits, everything was one-sided, they were at your mercy of the employers. Now they said, listen, every single employment will have to have an employment letter. The government has mandated that is made a statutory compliance to provide an appointment letter to all the employees. So even a sweeper, even with a sweeper, we will have to have a employment letter. Okay. Next, they have said a welfare officer should be there. Okay, they will think about the welfare and whatever issues the employers are having, how we can help them have a better standard of living. The employer to appoint a welfare officer for establishments of more than 250 persons. Earlier such a requirement was that when you had to employ welfare officers when they were 500 or more. Now the limit has been reduced and they are saying at 250 or more only you have to employ. So very, very important change, please note it down. that welfare officers have to be appointed whenever there are more than 250 persons. Earlier, it used to be said that when you have 500 only, then you have to appoint. Now, to only on 250 only you have to appoint. Next is women can work at night also. Okay, earlier it was said that no women shall work during the nights, but they can work even between 7 p.m. to 6 a.m. also upon their written consent. Then a new concept has been introduced which was never there before, which was about interstate migrant workers. Now what do you see? A lot of construction is happening in Delhi, in Chennai, in Mumbai, many places they are having, and they get these the migrant workers, laborers. Let's say they are getting the migrant workers from one state. Then when they come, they never used to get proper human facilities, or not necessarily that a law was there to ensure that it was there, that these welfare benefits were given to them. So now they said that migrant workers are workers who have migrated from one territory to another territory on my recommendation or through an agent, okay, who has been appointed by the employer from another state, having a monthly salary of less than 18,000. So migrant workers are workers who are coming from another state and having a salary of less than 18,000 per month. So if that is there, if an employer is having 10 or more migrant workers, he must comply with the code. So they will have to also give the benefits. Employers must provide suitable work conditions and even journey allowance, which was not there before, that even from coming to home, from your home state to the current state you're coming or back, journey to and fro journey allowance also should be given to the migrant workers. An employee or workman is required to provide his Aadhaar number to receive the benefits. Then even contract laborers are also covered. Contract labor also applied to interstate migrant workers. Okay, the code applies to establishment of employing more than 50 or more workers on any day in the last 5 years. National contract labor license is to be provided under the code. So let me explain. So we have a principal employer. Now who's a principal employer? Let's say Ambani. Let's say we have Ambani. You think Ambani really employs the lower end people? Answer is no. He appoints contractors to do work. So there can be a contractor. When these contractor hires these people, these are called as contract laborers. Okay, so they are called as contract laborers. So these contract laborers are those what you see on the road. They have made these the sheds are there and they are living with their family, doing all the road transportation, or you could say carrying the work for making the road. So they are all contract laborers. So what is happening is we are saying that listen, these are also can be migrant workers. So the definition also covers them, interstate migrant workers. They could also be migrant workers. You have to give them facility. That is what they have covered. And if a person is hiring more than 50 workmen, he has to get a contract labor license and it will be valid for 5 years. Now let's see some of the salient features. First is technological flexibility. So now they have started saying that they have started using the about incorporating technology, making databases, digital databases, keeping digital records. Everything is there. Technology has been introduced. Applicability. Okay, whenever there are 10 or more, this code will apply. Interstate migrant workers have also been made and their benefits have been given. First, addressing anomalies. Anomalies means what? Earlier, there was no definition and it was always in the gray area. But now it has been defined who's a migrant worker, and it has been stated that benefits have to be given to them. So legal identity has been given to these people working at such lower levels also. Traveling allowance has also been stated that traveling allowance should be given. Appointment letters should be made with them. Health checkup should be done at least once a year. Construction workers benefits, cess will be made, which is building and other construction workers cess fund. So whenever there is a cess fund, understand what is the difference between a tax and a cess. Can you tell me what is the difference between a tax? How is GST different from cess? How is income tax different from cess? How is export duty, import duty different from cess? Always remember, cess is only for a specific purpose. The money is collected for a specific purpose and can be utilized only for the specific purpose. And the purpose will be given just before that. So the purpose will be written here for what that cess is. So they will say water cess or which cess. So here they are giving building and other construction workers cess. So this cess money or the funds can come in from the government will decide, can give government grants. This cess fund can only be used for the welfare of building and construction workers. So this also has been made. Then ration card facility, one nation, one ration card. Okay, helpline number has been given for migrant workers. National migrant database, which I told you. Leave benefits. Now this is very, very, very important. What are they saying? Now again, for leaves also, paid leaves, they have increased and given more benefits. Let's see. Earlier, it was a reduction in the required work holidays from 240 to 180 for leave eligibility. In order to be eligible for leaves, I had to work in the last year for some number of days. So what they said that in the last year, if I had worked for 240 days only, then I become eligible for leaves. So now they have reduced the limit that even if you work for 6 months, 180 days, still you will be eligible for leaves. And for every 20 days worked, you will get 1 day leave. So very interesting. 60 days, 6 months you work, you are eligible to get leaves. Now how much leaves? 20 days worked, so 1 leave. So for example, if you work approximately 365 days, okay, so approximately you can say in a month you will get 12 to 15 leaves will be there in a year. Women empowerment, we are trying to get emphasizing on making women in different places and protecting women. Women working rights are to be done, where we are saying that all safety measures should be done when they are working at night. Okay, and also at the same time, equal pay, equal work, equal pay. Maternity benefits also has been provision of 26 weeks of paid maternity leave has been provided. Mandatory crèche facilities. Crèche facilities are where small babies can be there. So in certain factories, etc., where there are women employed, crèche facilities will have to be there. So so women can come, those who are these new mothers, they will come, they can keep their children in the crèche. There is the small play areas are there, so that should be there, provided to women. So this is protecting the dignity of women and dignity of motherhood as well. Formalization in employment, mandatory issuance of appointment letters, we saw that. Maintaining national advisory board, state advisory board. Again, safety committee should be appointed. Common license has been provided for all India license. It's a all India license for hiring contract laborers. Monetary penalties have been given. Courts may allow up to 50% of the penalties to the accident victim or their heirs. Epidemic and pandemic. Now again, this was never ever covered in the earlier laws, because only after 2020 we saw this kind of epidemic and pandemic point. Overriding powers have been granted to the central government for granting powers during any kind of pandemic, disasters, etc. Then we will see the code on wages 2019. Okay. So the code of wages has come replacing 4 core acts. There were 4 major acts. Payment of Wages Act, which said that when the wages has to be paid. Second, they used to say that what all deductions were allowed, what deductions were not allowed. That was the Payment of Wages Act. Minimum Wages Act. So they say that minimum this much has to be provided. For different sectors, they had provided that which all is the minimum wage. Bonus had to be provided, and we had equal, no discrimination between men and women, equal remuneration. The objectives of the code on wages 2019. A single uniform definition has been provided. So earlier we had, if you see 4 laws, so we had 4 definition of wages. Now what we have done is we have brought in a uniform, a single, one definition for all this. Then they have brought something called as floor wages and minimum wages. Can you tell me the difference? The concept of floor wages has been put, minimum wages were there before. Can you tell me what is the difference according to you? Think and tell. Okay. So very important. Minimum wages was different for different sectors. So for this sector, this is the minimum wage. If you're doing this work, this was the minimum wage. So every time they should tell what is the minimum wages. So that is still there. Central government will also say that there is a floor wage. No minimum wage in any sector can go below the floor wage. Clear? So floor wage is one wage which is saying no matter which sector it is there, it cannot go below the floor wage. Clear? So floor wage is the bare minimum. No minimum wages can be set below the floor wage. Equal remuneration, no discrimination to men and women. And a very interesting point they have also added now is inspector come facilitators. So appointment of these people will be there who will come, who will inspect, will enter into the places, check the samples, will be under the government control, and they will look after all the factories and the industries like a watch guard. Now, minimum wages under the code. So the minimum wages applies, unlike minimum wages, applies only to scheduled employments. Floor wage is a new concept, okay, and it says that the central government, after taking into account the minimum living standards of a worker, based on the floor wage, the central government will fix the minimum wage. Okay, again, very simple, important concept that the minimum wage cannot be less than the floor wage. So simple concept. Let's see what they have given. So salient features of the Code of Wages Act 2019. First is single wages they have defined. Holistic security. So everything has been covered under these things, not only for organized but also for unorganized sectors. Wage assurance has been given as per the minimum wages. Then you have the periodical wage review. So every 5 years they will review what wage, minimum wage they had set. Timely payment has to be given of your salaries, of your wages. No gender discrimination. Unorganized sectors are also covered. Regional wage balance. So again what they have said that no minimum wage can be below the floor wage set by the government. Now criteria based on wage determination, they will also specify that listen, you can have a difference of salaries provided the person there is a difference of skill of the job roles, etc. But similar job roles, similar skills, then there can't be any discrimination. Floor wage they have mentioned. Then they have said that digital methods have also been allowed for making payment of salaries and crediting into the account of the employees. inspector cum facilitators are there. They will remove any kind of malpractices which were existing. Penalty structures have been given, that different kind of offense, different penalty. So from here you can take up a few important points which are there. Okay, I have highlighted it. Advisory both. So more or less, if you go to see the codes, more or less have the same point. It will apply to organized, unorganized sectors. Income inspector cum facilitators will be there. Now let's see the next law, which is your Industrial Relation Code 2020. Again, any labor code, you will say that it consolidates various labor laws with respect to industrial relations. In industrial relations, they talk about dispute settlement. They talk about strike, where workmen or employees can go for strike. Employers can go for lockout, where they will shut down the factory. They are saying that the employees are not listening, are doing violence, so they will do lockout. This is temporary closure. Then there can be, they talk about retrenchment. Retrenchment is now there is, due to business conditions, we have to remove people. Okay, so that is called as retrenching a person without his fault. We are retrenching a person, and maybe he is not a good performer. Okay, or maybe the business is not that much, so we will have to retrench. So we will see what it is, the new points that are there. So the Industrial Relations Code 2020, strike now includes concerted casual leaves taken by 50 or more person in a given day. So we know strike is a refusal to work by the employees. Okay, it's not removal or resignation, it is refusal to work till the demands are met. Now, one of the hidden strike or hidden way of objection is 50% or more workmen are taking leave on a day that is also shown as it is a strike. 50 people cannot get, 50% of the workforce cannot get unwell at the same time. So that is also covered. Strikes are done by employees. Lockouts are done by employers. If you see in the Maruti case, where the employees had done violence, Maruti company, as a tactic to teach the employees, they had issued a lockout. That they said that we will not open the office till we receive an apology letter, or till the relations are made better. So that is a lockout by the employer. Okay, as a bargaining tool or a bargaining weapon. So strikes and lockouts are prohibited in all establishment without giving a notice. So my question to you, can a strike be done? Answer is yes. Can a lockout be done by the employer? Answer is yes. But they have said that now in the new labor code, you cannot go for strikes or lockout without giving 14 days notice. 14 days notice is mandatory. Because see, strike or lockout creates an economic disruption, eco-socio disruption. So therefore we are saying give a notice, see that if there can be any kind of negotiations or any kind of talks that is there. And then comes reskilling fund should be created, and you have to pay the worker reskilling fee, reskilling expenses should be done for the employee who has been removed. Let's say if I tell that, listen, your performance is not good, we don't want you, sorry, thanks. So now what law is saying that, listen, you cannot just remove someone. You have a right to retrench them, but listen, create a reskilling fund. It's a beautiful concept where you try to tell that, listen, we will pay. So it's a mandatory. Law is telling that, listen, if people are unemployed in the country, it shows badly on the country only. So reskilling, they will get to be skilled, especially when they are retrenched, so that they can find a better and a good job. Now again, very, very important point, salient features of the Industrial Relation Code. Definition of workers. defines workers to include supervisory personnel having wages up to 18,000 rupees. So what they're saying, definition of workers. So workers are including those who are having supervisory role having salary up to 18,000. If it is above 18,000 and they are in supervisory role, they are outside the definition of workers for this purpose of this act. Fixed term employment, again I told you that fixed term, they are employed for a fixed term, they should also get benefits just like permanent workers. Definition of industry, okay, so they have defined what is industry. Strike, I told you, when 50% or more go for casual leave on a day, it is considered to be a strike. Grievance redressal committee specifies a maximum of 10 members in a grievance committee, ensuring proper representation of women workers. Then Atal Yojana is there, which will provide for financial aid for job losses. As I told you, social security, there is a job loss, there has to be some financial aid given to these people. Retrenchment provision, very important, that this was never there, and it's a beautiful concept that upon retrenchment, when we remove a person, the worker should be provided 15 days of wages for reskilling. Trade union appeals. Now earlier what happened, that there was always dispute whether the trade union can represent. Case laws used to come out. Now they have put in the act only, in the code only, that listen, even a trade union can represent a workman. Then standing order certification. So standing orders are the rules, regulations, bylaws which will be applicable, the minimum terms that are there. So this will be done a threshold of 300 workers required for certification of a standing order. So 300 workers should be there to approve a standing order or a model laws. So 300 workers have to approve it. Then faster justice. Okay, in this act they are providing faster justice. Removes the reference system from industrial disputes adjudication. Strike and lockout regulations. So you cannot go, so this is important, 14th point, that you cannot go for strike or lockout without 14 days notice. So you can just see a few key words, and if they have given you a few numbers, please mark that as important. I've covered all of them. Okay, then statutory recognition has been given to trade unions, that trade unions can also represent the workmen. That's it. Now one part is enhancement of labor welfare and employment opportunities through the labor code. Tell me one thing, do you agree, after seeing all the highlights of the labor codes, that these labor codes are made for the welfare of workers? Yes or no? Yes. These labor codes will facilitate the implementation and also remove multiplicity of definitions and authorities. So due to the consolidation of all the laws, it will remove the multiplicity of definitions, multiplicity of registrations, multiple authorities which were there under this also same roles. Now they can have just one particular code, in that they will have officers, without compromising with the basic concepts of welfare and benefits. The code will bring the use of technology in its enforcement. So with time you will see that they are also using technology to nab or to track the employers and their activities in the factories. It will create transparency, accountability, provide minimum wages to everyone. So this is the facilitation for ease of compliance of labor law has also been brought in, which will ultimately increase the number of employment opportunities in India. So that is it. We've completed the entire chapter. You can take a note and or make a summarization of everything, and nothing else will come from what we have discussed. Thank you. Okay. So have you all understood clearly? Yes or no? I want you all in the this. So our Sumati, this is not applicable for the old syllabus students. It is only for the new syllabus, and we are covering the new syllabus. For the old syllabus, we will have marathon. We will have all the revision lectures. Right now, it is for the new syllabus that we are covering. Okay. So before I take a leave for the day, I have completed this entire chapter from the module in a span of 1 hour as promised to you all. Okay, so that is it, guys. Thank you so much. I've covered the entire chapter. It is your job to cover from the module lesson 14 and 15. Okay, so that is it. See you all, guys. Take care. Thank you.